Okay, so you are?
I'm Inspector Creed. I'm perfectly happy with you filming. No
Fine.
problem with you filming whatsoever.
Cool.
It's just the fact that you're on the police premises here.
Yeah,
and
but
we do ask the public to remain on the public
there's no
area.
signage. There's no signage. There's nothing blocking me from stopping me from walking round.
Well, there is a barrier there.
Yeah, that's for cars.
There's a fence there.
That's for cars. I didn't jump over anything.
Okay.
Yeah.
Is there anything I can help you with at all?
Yeah, you can stop abusing my rights and let me film. That's what you said.
I'm not stopping you filming.
Okay, then.
No problem with you filming
Well, I
at
can
all.
film in the car park. There's nothing stopping me from filming in the car park.
As part of our insurance reasons, as well as the security of the site, we don't allow members of the public on here. So that's why I'm asking you to leave and move out onto the public area. You can either go out here or you can go onto the public access area there. It's entirely up to you.
The inspector's very first move is to accuse Yardley of being on private police premises, but Yardley immediately exposes how weak that claim is. He highlights the obvious. There's no signage, no warnings, nothing at all to suggest the land is restricted. In law, if the public is not clearly informed that an area is private, they cannot be treated as trespassing. Access must be clear and explicit, not hidden behind vague assumptions or technicalities. When the inspector tries to lean on the idea of a barrier, Yardley shuts that down as well, pointing out it's a car barrier, not a pedestrian one, and that he never climbed over or bypassed anything to get in. That's the key difference. Walking through an open, unmarked space is lawful. Trespass only applies when someone knowingly enters an area they're not allowed in, and here the inspector had nothing to support his claim. Later in the video, Yardley moves behind the gate, into the very area the inspector confirmed was fine to record from, only to be confronted by two hostile officers.
Do your job first.
Well, I'm doing my job.
No, you're not. No, you're not. Step away, go away, get lost. I'm not listening to you. Do not talk to me. Listen, stop talking to me. No, I'm not going to listen to you. And if you touch me, right, that's going to be an assault as well. So just, look, you've got your hands up. You've got your hands up. Right, so excuse out of my way, please. Excuse out of my way. Excuse out of my way.
You can film.
Oh, listen to me. Please get out of my way. Please get out of my way. Get out of my way. Let me
The Chief
pass.
Constable holds the right to restrict your access, okay? You're more than welcome to film on the public bits, but we can't have you filming by the gate, obviously, because it's got a keypad, okay, which is a private
I'm not listening
access.
to you what you're saying. You're just talking. No, I'm not. You're talking to yourself, and I'm going forward. And I'm going forward. Do not listen. Listen, you're standing right in front of me. Right, so I'm. Why not?
Because it's an implied right of access.
No,
We have the
listen.
right
I've
to
got
remove you.
I've got a right of access. I've been told. Okay,
Okay.
by an
Yeah, you
inspector. By an inspector.
And this right of
Okay.
access is now being revoked.
No, we'll go and get an inspector to revoke it because I've been told
We're
I've
asking
been
you to
told
move
by an
on to
inspector
the
that I
don't
can
need
film
an
here.
inspector. I don't need an
No,
inspector.
well, I've been told that I can film here.
What I am happy
I've
to
been
do.
told. No. Listen.
told you about what's upsetting you.
Nothing. Well, you're upsetting me because you're not doing your job. He just went and threatened me.
Right, but the reason I hear...
No. He just went and threatened.
The officers try to push Yardley back from the gate, even though he is clearly standing on public land. One officer falsely claims that the implied right of access gives them the authority to remove him. That is entirely incorrect. Implied access applies only when members of the public enter private property for a lawful reason, such as approaching a house. It has no relevance to someone on public ground, meaning they had no legal basis to move him. Yardley reminds them that the inspector had already told him he could stand there, which should have ended the dispute. Instead, the officer escalates matters by insisting that Yardley's right had now been revoked. Only the landowner or someone with proper legal authority can revoke access, and Yardley wasn't even on private property. When the officer further claims he doesn't need the inspector's
Listen, you're standing
authorization,
right in front
it
of me.
only exposes how reckless,
Why not?
uninformed,
Because
and
it's
basic
an implied right of access.
No, he just went and threatened me. So you're telling me somebody can threaten you anywhere, but all you're worrying about is me not filming in a place
At
of...
the moment, yes.
Yeah. Why?
Correct.
Who started the initial crime? Who initially evoked
At
a
the
crime?
moment, I'm here because you're here,
No.
filming in a place you're
Well, you
not allowed
shouldn't
to
be.
film.
You should be after that guy first because he's getting away. Who is he?
At the moment, I
Who's
don't
that
know.
bloke?
I don't know.
Why don't you know that?
Because I don't work with him.
So how are you going to find him?
Well, we've got CCTV, I'll identify
Okay.
that, okay?
Oh, yeah,
what I'm more concerned about at the moment...
No, I'm not going nowhere. I've been
that
told
you
that I can
can't
film it. I can.
You can, but you
I can
can't
film
film
it.
here.
I can film it. No, and I'm telling you that I've been told by an inspector that I can film here.
inspector was it?
Okay, Inspector Creed. Okay. Now, off you go, because this is what he said, okay? I can film here. So unless another inspector comes down and wants to tell me that, no, I'm not going to take it from you.
I have the right to tell you can't film.
No, you're not going to supersede the inspector because he told me that I can film here.
From my sergeant and from my inspector.
No. Which inspector? Who's the inspector?
Inspector Cutter.
Okay, where's Inspector Cutter?
He's in the building.
Okay, we'll go and get Inspector Cutter to come out and tell me.
Because I'm asking you.
No, and I'm politely refusing and I'm declining because I've already been told by Inspector Creed that I can film here. So
we have.
I don't believe you. I don't believe you.
Overrule that.
The exchange shows just how far the officers were willing to twist the truth. Yardley repeatedly reminds them that an inspector had already told him he could film from that spot, which should have ended the discussion. Instead, one officer claims another inspector said Yardley couldn't film but refuses to produce that inspector when asked. When Yardley references Inspector Creed again, the officer escalates, declaring, "We have the right to overrule that." That claim is nonsense. A constable cannot overrule an inspector. The rank structure simply doesn't work that way, and the law certainly doesn't bend to an officer's opinion. Filming in public is lawful, and no officer, regardless of rank, has the power to rewrite that reality.
Wait, do you know something? You're trying to talk, right? And I've already told you. No. It's not that you're making sense or not. I've already told you that I'm not allowing you to talk simply because I want you to do something which you haven't done. So therefore, by you carrying on with your waffle, right, I'm giving you that opportunity to talk. But I'm not going to give you that opportunity to talk, so I'm going to stop you right there. When an inspector comes out, then he can tell me that. I'll tell him that what Inspector Creed says. We'll have that discussion there. Because as far as I'm concerned, I have been given the right to film here. No, I'm not talking to you no more. I'm telling you. Right? I've just told you.
But why let's have a conversation?
Don't worry about it. All right?
I don't understand why you're being
because I want you to go and sort out this first thing. You're not doing it. You're not doing your job. You're standing there, wasting time, my time, your time, everybody's time.
What's the reason for filming here? That's what I don't think you can. But what's the reason?
Well, it'd be a bit hard to draw stuff, so I've got my camera out.
Now, cam footage. The same two officers return to Yardley, threatening him with arrest if he refuses to leave, escalating their intimidation.
Wait, do you know something? You're trying to talk, right?
Leave.
So what I'm saying to you, okay, all we need to know, or what we're happy with you doing, is filming, obviously outside of the more public areas. That's absolutely fine. Don't stop you doing that, okay? All we ask that under Section 68 of the Criminal Justice Public Order Act 1994, okay, is not to film.
Are you detaining me?
No, not at the moment.
Are you giving me a caution? Stop telling me to listen.
I'm giving you a warning.
Stop. No. Are you cautioning me?
I'm not cautioning you.
Well then, I don't want to hear no section, nothing. Am I doing anything wrong? Am I doing anything wrong? No. Am I doing anything wrong? Am I doing anything wrong?
Registration plates are doing something wrong.
Listen. Don't tell me that I was filming registrations plates, okay? Get some concrete evidence and then come and start telling me all these things. Otherwise, go away. You keep on. You just did.
I'm telling you, under that section.
Under what section? A section what? Doing what?
Is if you begin to start filming registration plates, keypads, people coming in and out of the building, it's obstructing the day-to-day business.
No, it's not. I'm not obstructing anybody, and I can stand in. Get lost. Do you know something? I can stand in a public place and I can film whatever I want.
Yeah. And we can arrest you for aggravating trespass.
You can't.
Okay.
You can't.
Yes, we can.
Get lost. You can't.
Yeah, we can, and we will do if you carry on.
Section 68 makes it an offense to trespass on private land with the intent to disrupt or obstruct lawful activity. Yardley's situation was far from that. He was on public ground, filming quietly and not obstructing anyone. Filming registration plates is not illegal, as they are displayed publicly by law. Suggesting that Section 68 applied here showed a clear misunderstanding of the legislation. Rather than backing down, the officers doubled down. When Yardley went inside to file a complaint, the same two officers returned just 5 minutes later and arrested him under Section 68, demonstrating a blatant misuse of authority and a reckless disregard for both the law and Yardley's rights.
Do these questions relevant?
Oh, just curious so I know how to treat you, what your experience is and what you may or may not know.
I'm not somebody who gets myself into trouble.
Okay, no, that's fine. Right, well, long story short, I'm the Classic Sergeant, so it's my job to look after you here, and I'm sure you're dealt with fairly as well.
Okay.
To that end, I'm going to ask obviously a few questions to find out why you're here, and I've got some questions for you, see how you're doing physically and mentally.
Okay.
Bearing in mind when I ask the officers about why you're here, that is them explaining why they've done what they've done. That is not an allegation to you for you to sort of necessarily reply to, okay? Because otherwise we'll end up in a conversation, I suspect.
Oh, yeah.
Okay.
Yardley's arrest under Section 68 was not only thrown out, it ended up costing the police force thousands of pounds, while Yardley himself walked away with £1,500 in damages. The financial breakdown is striking. Over £2,000 was spent on counsel and court fees, with nearly £5,000 in additional costs, bringing the total to close to £10,000 once VAT is included. And who ultimately pays for this? Not the officers who lied about their powers or carried out the unlawful arrest. It is the taxpayer. The public shoulders the cost of officers failing to apply the law correctly. This is an insult on top of an injury. When police abuse their powers, it isn't them who face the consequences. It is the public. What makes this case even more egregious is that the entire legal fight was avoidable. If the officers had stuck to facts rather than their own ego, there would have been no lawsuit, no settlement, and no wasted public money. Instead, they doubled down on an arrest they had no lawful grounds for, forcing the case to court where it collapsed. Settling became the only viable option for the force because defending the indefensible would have cost even more. This is exactly what happens when officers believe their authority outweighs the law. Yardley was not trespassing. He was standing on public land, openly filming and bothering no one. Trespass itself is not a criminal offense. It is a civil matter. For aggravated trespass to apply, trespass must exist first. In Yardley's case, there was no trespass, meaning Section 68 could not legally apply. The defense wording made this crystal clear. If someone is not trespassing, the law simply does not support applying Section 68. The legislation is not subjective. It doesn't bend to a police officer's opinion, and there was no evidence that Yardley had obstructed, intimidated, or interfered with anyone. The officers tried to stretch legislation that clearly didn't fit the circumstances, and the court saw through it immediately. Yardley was entirely within his rights. He was standing on public land doing something lawful, and yet the officers tried to frame his lawful actions as criminal. This wasn't merely sloppy policing. It demonstrated a dangerous willingness to let personal discomfort or irritation dictate how the law was applied. Their misuse of Section 68 was the clearest example of this failure. Aggravated trespass is specifically designed for situations where people deliberately disrupt lawful activity on private property. Yardley was doing none of that. Applying Section 68 to his actions was a gross misapplication of serious legislation, revealing either a shocking lack of understanding or a reckless abuse of power. The arrest itself revealed the officer's true mindset. Yardley had gone back inside to lodge a complaint, as he was entitled to do, and within minutes the same two officers arrested him. Nothing had changed in that short time. No crime had been committed, except that Yardley had dared to challenge them. This makes the arrest retaliatory, not lawful, and strips away any credibility in their claim that they were merely keeping the peace. The financial fallout highlights the broader consequences of such misconduct. The police force had no choice but to settle, paying Yardley compensation and covering thousands in legal fees. Once again, the cost fell to the public. Taxpayer money, which could have been used for genuine policing, was instead spent rectifying a situation caused by poor judgment and unlawful behavior. This episode illustrates the fragility of policing when procedure and law are replaced by emotion and ego. Throughout the incident, Yardley remained calm, logical, and within the law, while the officers repeatedly erred, escalating frustration into an unlawful arrest. The court vindicated him, proving that when officers overstep, it is not the law that protects them, it is the public who ends up paying the price for their mistakes. Yardley's experience serves as a clear example of how vital it is for law enforcement to adhere to proper procedure and respect the legal limits of their authority. This case also highlights the danger of officers misinterpreting or misapplying legislation. Section 68 is serious, intended to prevent real disruption and obstruction, not to punish citizens exercising their lawful rights in public spaces. When officers act as if their discomfort or disagreement with lawful behavior constitutes a crime, it undermines public trust in policing. Yardley's case demonstrates how quickly an abuse of authority can escalate into unnecessary legal battles, costing taxpayers and damaging confidence in law enforcement institutions. In the end, Yardley did not just win in court. He proved on camera that lawful behavior cannot be criminalized by misunderstanding or misapplication of the law. His calm, measured conduct contrasted sharply with the officer's reckless approach. The incident is a cautionary tale for both the public and the police. Authority does not equal infallibility, and the law exists independently of any officer's personal interpretation. It also reinforces the principle that when officers exceed their powers, the public, not the officers, often bears the consequences.